We are back. I'm your host, Dave, and we are back to another episode of Everything Intellectual Property. And today we have a special doozy for you. Who are we talking about today? Let's get straight to it. We are talking about the one and the only Adidas. You see there, the stripes. They're suing Aviator Nation, which appears to be a company out west California. They have a number of brick and mortar stores. It seems like their presence online has grown over the last 3 or 4 years. So look I have to tell this quick story. So back growing up in Michigan here, I haven't had too many pairs of, I guess, Adidas, whether it's clothing or shoes. But I remember this one time I had some shell toes. You guys are gonna have to let me know in the chat. Is shell toes still even a thing? I remember I had the shell toes, and then they had the 3 stripes on them, but the stripes, they were like this Georgia Tech. They were like two-tone, so they're like this Georgia Tech black and gold, where they faded from black to gold or gold to black. Them joints were sweet. And I remember vividly in like middle school having them joints on. And again, I went to a middle school in an urban area, and then you had this is going to be a great moral of the story at the end, but you will have people come in, and I'm not sure if they even sell these shoes where they had the 4 stripes. They weren't Adidas because they was 4 stripes as opposed to 3 stripes, but they was like a less, they inexpensive option. So you go to like a Walmart or something like that and say Adidas, at least shell toes at that point in time, 60, 70 bucks. But you had the 4 stripe shoes. You can get them at Walmart, for example, like 30 or 40 bucks. And man, if you came to at least where I was going to school at in the 4 stripe boys, hey, they got at you. They roasted you hard. So I guess moral of that story, and we all broke in that urban environment in the middle school where I come from, but we were kind of ragging on each other for essentially for shoes and stuff like that. So more to the story, school in the urban area, and if you do, they may they may get talked about for wearing that type of cheaper clothing, even though everybody is broke. So again, let that be a lesson. And another thing I did wanted to talk about, I guess I didn't bring this back up on me. Another thing, and I do want to talk about Aviator Nation. Like I talked about earlier, they're a company on the West Coast. You see here, and it's actually a decent sized company here. The founder, you see Paige McCoskey. They have, just over 300,000 followers. So they are a decent sized company. If we go to, their website here, which it seems like, from my understanding, they just recently took off not too long ago. And the stuff is, man, it's pretty pricey. You see $189, $156, $189. We talking about sweatshirts and sweatpants, just one item. So their stuff is a little pricey. And hey, I want to first put some respect on Paige McCoskey, the founder, the CEO of Aviator Nation. And I want to get you on the podcast because what you did with this company is nothing short of amazing. So I got to put some respect on your name. She literally built a company that is, as of 2023, has done $130 million in revenue just that year alone. She's built that from the ground up. I think she started in 2006. We're going to get off into the how I built this podcast, which she was on, and I listened to that podcast. Her story is amazing. Like I said, started in 2006 with this Aviator Nation brand, and as of 2023, it did $130 million in revenue, annual sales that year alone. So major respect to you. If you are seeing this, or if you're happy to see this, this is no shot at you. Definitely major respect. I would love to get you on the podcast just to go through your story. But again, we have a little order of business to get to, and we're just using this for research purposes. Just trying to learn get to some learning lessons, what not to do, maybe what to do to maybe avoid this situation that you and your company has found yourself in. And again, nothing against you because you have done some great things. So let's get off into, and please check in the chat. Let me know who we got in the chat. I see we got some visitors here. Please let me know who we got in the chat here. And we're going to get to the order of business here. I like to bring up the complaints here. Let's see here. And this is going to be a good one, man. This is going to be a good one. So this is who we're talking about. Adidas America. I bet a lot of you guys didn't know that Adidas is actually a German company. It started in Germany. and they have Adidas America as well as Adidas AG, which is a German company. They're suing Aviator Nation and Paige McCoskey, as I talked about before. Paige, man, mad respect to you. You built this company up with no debt. I'm talking about she built a company up that did $130 million in revenue selling clothes last year with no debt. So major kudos to you, but and we got to get down to business here. Oh, we got Brandon in the chat. Hey, what's going on? Okay, CT. Charles Terrell, let's get it. We got Brandon. So what's going on? Love the show. I love you too, Brandon, man. I appreciate all the support. Let's get it. My man CT is in the building. Adidas is bigger than Nike worldwide. Hey, I would agree with that. As we go through this complaint here, man, Adidas, it's a pretty big company here. So let's get to the order of business. Plaintiff Adidas, American Adidas AG. Essentially, they're suing McCoskey and Aviator Nation. Hey, let me know if you guys have heard of Aviator Nation. In the chat, let me know if you guys heard of this company called Aviator Nation. Apparently, they have 5 or 6 brick and mortar places out west in California, but they've done a lot in online sales over the course of the last 3 or 4 years. So, but for decades, getting back to the introduction here, for decades, Adidas has manufactured, advertised, marketed footwear and apparel, an array of colors, bearing its famous and distinctive 3-stripe trademark, which is covered by numerous incontestable federal trademark registration. And as we talked about before, when you're talking about an incontestable mark, that just means that their trademark has been in existence without issue for 5 straight years. Consumers readily recognize Adidas 3-stripe mark. I think we can all agree in the chat that Adidas is a famous trademark. As Brandon just talked about, Adidas is bigger than Nike nationwide. So I think we can all agree that Adidas mark, their 3 stripes, the name is a famous mark. Okay, so Brandon, he says that they're located in Cali. Hey man, this she has done her thing with this. So let's continue to read the complaint. Over the years, Aviator Nation repeatedly has ignored Adidas rights in 3-stripe marks, requiring Adidas repeatedly to object to the sale of infringing sweatshirts, sweatpants, hoodies, all type of clothing apparel that are confusingly similar. So it seems like Adidas is saying, hey, Aviator Nation is selling some clothing that's confusingly similar to our famous trademark 3-stripe logo. And settlement agreement signed in 2012. So this is going back over 10 years. It seems like I said, Aviator Nation has been around since 2006. It seems like Aviator Nation and bring it back on myself. It seems like Aviator Nation and Adidas have been going back and forth for a long time. It says they had an agreement signed in 2012, another agreement signed in 2013, and then this most recent agreement was signed in 2022. Collectively, the agreements, Aviator Nation acknowledged Adidas' rights, agreed to stop selling apparel Adidas had identified as infringing the 3-stripe mark, and committed to stop essentially manufacturing and marketing the product that was confusingly similar to the 3-stripe, the famous 3-stripe trademark. Each of the agreements was signed by the CEO and founder, Paige. So it seems like Paige is saying, hey, I'm going to call the dogs off. I'm not going to sell any more of these clothing. And I guess for that matter, y'all got to let me know in the chat. Do y'all think that this, we're going to bring back up the clothing. Do y'all think that this is similar? Would y'all get confused with this clothing and say it's similar to Adidas 3-stripe brand? Y'all have to let me know if they're going to bring up the picture. Looking at those jogging pants, would y'all get those confused with Adidas, the 3-stripe mark? Or would y'all say, no, it's more colorful, got a couple more stripes. I don't think that's Adidas. Y'all got to let me know in the chat. What do y'all think? Would y'all get confused if y'all was running to Aviator Nation or running to these clothes somewhere on the strip, say you in California on Venice Beach? Would you get confused that this is associated with Adidas? Yes or no? Y'all got to let me know that. That's the ultimate question with this. Let's get back to the complaint here. This thing is going to start turning up because it was a lot of okie dokes in this one. It was a lot of okie dokes. So let's get back to the complaint here. Each of the agreements, so it was 3 agreements, 2012, 2013, and 2022. Each of the agreements contain a confidentiality provision requiring the parties to keep the contents of the agreement strictly confidential. So not only included in this agreements that Page and Adidas signed, there were confidentiality agreements saying that you can't disclose the terms to anyone. And it seems like Miss McCoskey Page, the owner CEO of Aviator Nation, appeared on this podcast and had the following to say. And let me just say, it was actually a pretty good podcast, man. I got mad respect for Paige after listening to that podcast, but I was trying to find the actual excerpt that Adidas attorneys included in the complaint. I was trying to find that in the podcast, but they must have had the podcast host cut this excerpt out the podcast, because as I listened to the podcast, I was not able to find this excerpt. So I'm assuming that once they got wind of these lawsuits, they had the attorney cut it out. They had they had the show host cut it out. So this essentially what Paige said on the podcast. She said basically what happened was she's at this point, it seems like she's talking about these agreements, these confidential agreements with Adidas. So she's saying basically what happened was in 2012, there were a couple garments that did have the 3 stripes. So it seems like she is admitting to selling the 3 stripe garments. I basically said, okay, I'll stop doing the 3 stripe garments, but I'm going to continue doing the 4 stripe. And so they like basically disappeared for several years. So she's saying Adidas disappeared for several years, and I stopped doing the 3 stripes. And so anyway, they came like years down the road. She's talking about Adidas seemingly came back. I want to say maybe 2016. So Adidas came back in 2016, apparently. They came back and said, oh, now we think your 4 stripes are confusingly similar. And I was like, no, guys, we made this agreement. And so anyway, in 2016, she's talking, I had a little bit more money. So it seemed like she got her dollars up in 2016. And she's saying, I think at that point, I actually had insurance for trademark protection. And let me trademark protection. This is a very important thing. This is not talked about a lot, but if you're starting a small company, a lot of times that business owner would get trademark insurance so that if they accidentally infringe on the trademark of a bigger company and that bigger company sues you, then as like insurance with your car, insurance with your house, that insurance company will pay the lawsuit if that happens. So again, it's used a lot of times by smaller companies. I guess bigger companies can use it as well, but smaller companies, as they're starting up their company, they don't want to get sued for trademark infringement and get put out of business. So they would get trademark insurance, so that if they get sued, then the insurance company will pay the bigger company, the lawsuit or the judgment, and all is well, they can continue to run the that she got the trademark protection. So this went on for a long time, and we did go through mediation. And so she's saying that, man, they had pretty much some back and forth, her and Adidas attorneys. We just settled on the fact that I wouldn't do the 3 stripes, and I would really not do anything with the 4 stripe that was confusingly similar. So essentially, she's saying in this big paragraph, she's saying, hey, Adidas came to me. Yeah, I had some 3 stripe garments that I was selling. I told them I'll stop that. Then they went away. They came back years later and said, hey, with this 4 stripes that you're doing, we don't want you to do that either. And she like, hold on. We had an agreement for the 3 stripes. Now y'all don't want me to do the 4 stripes? All right, man, look at this, what I'll do. All the 4 stripe stuff that can be looked at as similar to yours, I'll stop. And it seemed like that was the agreement between Adidas and Paige, who's the CEO and the founder of Aviator Nation. But again, the interesting thing was that this agreement had a confidentiality provision, and we all know what confidentiality is. You can't talk about it to the public. You can't disclose the contents of this agreement to other people. And she's on this podcast. Hey, that's a good and a bad about podcasts. These things get you in trouble, get you publicity at the same time. So she's talking about how she came up, how she built her company, and next thing you know, she's getting hit. She's spilling the beans on some confidential stuff that she shouldn't have been talking about. And, essentially she got hit with the lawsuit. And the interesting thing is, if you go look at the podcast, like I talked about, they cut this paragraph right here. So this big paragraph that you're seeing that I'm highlighting, they cut that out of the podcast. So it seems like maybe she wasn't supposed to say that part. But just moving on to paragraph 5 here. Paige said in the Paige's public statement not only breached, okay, so the Adidas attorneys are saying she breached the 2020 agreement based on these public statements. And also, it demonstrated the contemptuous indifference she and her company repeatedly have exhibited for the duties and obligations that she undertook in the agreement. So Here's pretty much exhibit 1. This is what she said. This was what Adidas saying per the agreement that she said she would stop selling. And this is what she's continuing to sell. So again, I asked you guys in the chat, do you guys think that this is similar to Adidas' famous 3-stripe marks? Yes or no? She's saying in the 2020 agreement that this particular item she's going to stop selling, but she's still selling it, even with the jacket. With the marks across the front. She's saying that she's going to quit selling this per the 2022 agreement, and she studies selling them. Okay, we have so this is kind of looks a little bit closer to the Adidas. You maybe got a better argument for the orange, red, yellow shading, but as you start to get to this color, it does get a little bit more interesting. And I'm gonna tell you why it gets interesting. We're going to go to her website. We're going to go back to the website that she has. So if you go to if you go to her best sellers, this is why she's continuing to sell them. It seems like this is part of her best sellers. The hoodie with the it seems like she has in this case 5 marks or 5 stripes. You got the sweatpants with the 5 stripes. Again, the sweaters with the 5 stripes. So again, this is the best sellers tab. So this is one of her best selling items. So, I mean, I guess I get why she's continuing to sell it, even though she told Adidas per the agreement that she's not going to sell it. Hey, this is one of the popular items. So, I mean, that's interesting. That's a little interesting to me. So let's get back to the complaint here as we start to heat up. Let's see here. Chrome tab. Let me see where we at. Where we at? Okay, here we go. Adidas. Bada boom, bada bang. Add to the stage. So we get back to the complaint. Paragraph 7. In addition to these designs, Aviator Nation, aka Page, with actual knowledge of and at least express direction, continue offering to sell. So they're saying what I just said before, that she not only stop selling them, she's continuing to sell these items. So going to paragraph 8, Aviators Nation latest infringement apparel imitates Adidas 3-stripe mark in a manner that is likely to cause consumer confusion and deceive the public regarding this source, sponsorship, and all that extra stuff. I'm not sure why they're not capitalizing their sentences, but paragraph 9 here, Adidas hope to avoid bringing a lawsuit. So Adidas is saying, hey, we didn't want to do this. And sometimes, unfortunately, you got that bully that keeps coming back and you don't want to fight him. But sometimes you just have to knock him off. And I'm not saying that Paige is a bully in this case, but you can tell clearly that Adidas didn't want to sue this lady. They had a 2012 agreement, another agreement in 2013, and then another agreement in 2022. So they just kept reaching out to her. Hey, we're not trying to sue you. Let's sign this agreement saying that you're going to not sell these items. And she's continuing to sell them, breaching the agreement. At some point, Adidas like, you know what? Hey, screw this. We're going to slap you with this lawsuit. And here we are talking about the lawsuit. So on to paragraph 9. So again, Adidas is saying they hope to avoid bringing this lawsuit by attempting to reach an amicable resolution with Aviator Nation and Page. But in spite of the fact that the 2022 agreement required that the parties to mediate, Page refused to attend a party's mediation in person despite Adidas' repeated efforts. So it seems like, hey man, Page, she like, forget all this. I ain't going to nothing. So Page scheduled and extend the time in which to conduct the mediation. Despite Adidas' efforts, the party. So it seems like, hey, they can't get a hold of Page for mediation. So paragraph 10, this and therefore an action at law and equity for breach of contract. So and this is the suck thing. This is the bad thing about this. Not only is Page on the hook for potentially trademark infringement, but now these are these agreements that they had in place, which is a separate cause of action from the trademark infringement. And based on a breach of those agreements by not selling those particular items and not disclosing confidential information, now you're on the hook for contract breach. So man, it's interesting that Page is taking this approach, but let's continue to read and see what this. Yep. trademark infringement, dilution. Okay, the pretty much the normal stuff. So let's look at the parties. We all, as we talked about earlier, Adidas is a company based in Germany. They say you have plaintiffs, Adidas America, so they have an American division essentially. As Brendan alluded to in the chat, hey, Adidas bigger nationwide. They're Nike worldwide, and obviously as a result of that, it's a famous mark. So going to paragraph 13 on information of belief, Adidas or Aviator Nation is a corporation organized in the laws of Cali. So as Brandon talked about it, also they're in Cali. We're going to skip the jurisdiction and venue stuff. We're gonna get to the facts, the juicy stuff. Adidas is currently for many years has been one of the leaders, footwear, apparel, all that. I didn't realize that Adidas was it was around since 1952, using a 3-stripe mark on footwear sold in the US and worldwide. Going to paragraph 20. As early as 1967, seems like that's when they had the 3-stripe mark on apparel sold in the US and worldwide. And as we have here, you have the 3 stripes, the famous 3 stripes, Adidas going down the sleeves of t-shirts, of hoodies, of the sweatpants, the famous 3 stripes. Them shell toes I was talking about earlier. Them shell toes are sweet. I don't so much see people rocking the shell toes. Maybe I ain't out like that these days. But you can see the famous 3 stripes going down the shirts, just on a lot of apparel. Adidas is the owner of federal trademark registration, which they're pretty much saying, hey, we have a federal registration. And I know a lot of people, you didn't think that you can get federal registration on essentially striped lines. Not only can you get federal registration on a logo and on a word, but you can also get federally via a registered trademark on, in this case, 3 stripes. And actually, I'm going to show you guys something that's even more interesting. I'm going to show you. Now, this is pretty interesting. And just because you have a trademark does not mean that people cannot sue you. Let me say that again for the people in the back. Just because you have a trademark does not mean people cannot sue you. Check this out. Aviator Nation actually has a trademark on 4 stripes. Now, it's they claim the color, so the stripes have to be red, orange, yellow, kind of orange red. But Aviator Nation has a trademark on the 4 stripes, and they have it in the goods and services clothing class 25, which we all know, pants, shirts, shorts, sweatshirts. So you may be asking, Dave, how is it that Adidas can sue Aviator Nation for something that they have the trademark on? And as I said before, just because you have a trademark does not mean that you can't get sued. And I'll even say the way that attorney to attorney, IP attorney to IP attorney, the way that Aviator Nation got this trademark was pretty clever. So when you file a trademark application, you have to submit something that's what is called a specimen, pretty much showing that you're using the mark in commerce. So that specimen can be a number of things here. And we're going to show you one of the specimen. So this is, let's see here. Is it not, this is not, let me do this really quickly. It's not on what's name, but we'll get it. So this is Adidas specimen. So when they filed their trademark application on the 3 stripes, this is their specimen. They're showing it on clothing or on one of the goods that they're going to be selling. So in this case, you can see the 3 stripes on the arm of this jacket, this Adidas jacket. Let me stop sharing the screen here and go to the next one. So when they submitted their specimen, this is what they submitted. So the specimen is the 4 stripes on a tag. And as we go to their trademark application, I know I'm doing a lot of switching, but I want y'all to see how the attorney tried to game the system. And this one was this was, they thought they was going to get away with it, but I don't think they are going to get away with it. Where is it at here? So this is Aviator Nation's trademark application. And hopefully you guys can see this. Let me see if I can blow it up a little bit. Okay, there we go. So they're claiming, first and foremost, they're claiming the colors of their stripes. You got a dark red, orange, a light red, orange, yellow. So they're claiming the colors of their mark, but then they're also saying, hey, they're claiming an order, a dark red, orange, followed by a light red, orange, followed by an orange, followed by a yellow, horizontal stripes. They're claiming this is the description of their mark. But if you go down a little bit, okay, with the description of the mark, they're saying apply to hashtags. So what they did was, which I thought was, the attorney tried to get away with it, and I don't think they're going to be able to get away with it. When they submitted their specimen, because I'm telling you that when you file a trademark application, at some point you're going to have to submit a specimen saying that this is how an example of how you're using this trademark, in this case, on your goods. And her specimen included, again, these 4 stripes on the tag. Now let me ask you something, chat. Do you think that when she submitted this specimen of the 4 stripes on the tag, she knew that she wasn't going to use them like that? In other words, do you believe that Paige, when she had her attorney submit this specimen, she knew she was going to use them similar to the way the Adidas are using them down the arms of a jacket or a t-shirt and down the sweatpants? I think it was clever, because if she would have showed her specimen similar to Adidas with 4 stripes, that's red, orange, yellow, and then a 4th line, she would have got a rejection. And in my opinion, I think that she showed her specimen with the marks on the tag to try to avoid getting a rejection from the office action, which they did. And again, let this be a lesson to you guys. At some point, if you do shady stuff, it's going to come back up to you. I think, again, she submitted this tag that's attached to the clothing as a specimen, when she knows she wasn't going to use the mark like that. And then when she starts selling the clothes, she started using a mark in a similar way that Adidas was using a mark, but it had 4 stripes as opposed to 3 stripes. And Adidas saw it and they came after her. So even though she literally has a trademark, I'm showing you, she has a trademark, a registered trademark. She has a registered trademark. Just so you guys are not getting confused. She has a registered trademark on 4 stripes, and she's being sued for using her registered trademark on her clothing. And for those of you who are just joining us, let me show you some of her clothing items. Let's show you some of the clothing items. Let's see here. Bada boom, bada bang. These are her clothing items. So she's using, and again, the agreement made sense, because the agreement, we'll get back to the complaint here in a little bit, but the complaint is saying that, hey, stop using the 4 stripes, and she went to 5. That's why you see if you notice, even though she has a trademark for 4 stripes, she went to 5 stripes on her clothing because of one of the agreements with Adidas saying, hey, stop selling your 4 stripes that look similar to our 3 stripes. And she said, okay, I'm going to stop selling those particular items. And she ended up going to the 5 stripes, and Adidas is still having an issue with it because it's confusingly similar. Do you guys think that these are confusingly similar to the Adidas? You're looking at the items that she's selling. Do you guys think that these sweatpants and sweatshirts by Aviator Nation is similar to the 3 stripes of Adidas? I think so. I think that they have a claim. And again, look at the tab I'm on. These are the best sellers tab. So that's why she's breaching the agreement, or allegedly breaching the agreement, is because these are some of her best items. Now, I'm not sure if I'm paying $189 for a hoodie or a sweatshirt, or $150 for some sweatpants. Adidas definitely got her beat in prices. I mean, that's crazy. $156 for some sweatpants, $189 for some hoodies. And again, the thing is, if she was selling this, she would have been good. If she was just selling this sweatshirt with the AN, with the 4 stripes, I think Adidas would have no problem with this. You got the gray hoodie with the AN logo with the 4 stripes. Adidas wouldn't have any issues with this. Even this, I don't think with the Aviator Nation in circle, with the 5 stripes, with the surfer, Adidas would have been cool with that. But as we get back to the complaint here, Adidas has an issue with her selling these items. Get back to the complaint. As we go up here, Adidas has an issue with her selling these items. The 2022 agreement, they're saying she agreed. Hey, Adidas, I will not sell these items. This is what this says. Products Aviator Nation agreed to stop selling in 2022 agreement. And these are the products she continues to sell. We just looked on the website. So if in a 2022 agreement it says that she won't be selling them, it's definitely at the very least breach of contract because she's selling them. We just looked on the website. She still has them for sale. So let's continue to get then where did we leave off here? Let's go to 23 or whatever. They're just talking about the trademarks that Adidas has, so nothing new with that. That's the 3 stripes. Nothing special there. Adidas has invested hundreds, paragraph 30. Adidas has invested hundreds of millions of dollars building this brand in connection with the 3-stripe mark. And federal courts repeatedly have stated that the 3-stripe mark is famous among consumers in the U.S. Indeed, for 50 years, Adidas has advertised and promoted the 3-stripe mark in the U.S. through virtually every marketing channel. And you guys may ask, what do you need to do to have a famous mark? Well, you better have a shit ton of sales, excuse my language. You better have a ton of advertising and marketing geared towards the actual product. And I think we can all agree that Adidas over the years has spent billions of dollars in marketing and promotion of their products, as well as have made billions of dollars off the sales of their product. They have registered trademarks. They have had registered trademarks for decades. So I think we can all agree that it's a famous trademark. So let's go back to paragraph 31. Since introducing the 3-stripe mark, Adidas has spent, this is what I was just saying. And I said billions, but at least they said they spent millions of dollars promoting and marketing it. So I guess they haven't spent billions. Adidas has used the 3-stripe mark in connection with frequent sponsors. So obviously we're not going to go through all the sponsors that they have had for the 3-stripe mark. Let's see here, paragraph 33. It seems like they're saying that they've used it in television, the 3-stripe mark, television, social media, festivals. I mean, they've used the 3-stripe mark pretty much everywhere. And then we're not going to look at the exhibits, but they attached a ton of exhibits kind of showing that. Seems like they even had some collaborations with some iconic brands, Prada, Gucci. Hey, you guys let me know if you have ever saw the Gucci Adidas partnership or the Prada Adidas partnership. It seemed like they had a partnership with Balenciaga and some other well-known fashion brands. Let me get to Adidas advertising campaign. They just talking about their advertising. See what else is good here. Adidas has built up, paragraph 38, Adidas has built up and now owns extremely valuable goodwill. I think we can all agree that they got the goodwill in the 3-stripe mark through its continuous efforts. Okay, here we go. Aviator Nation prior agreement infringement. So now we're getting off into the 2012 and the 2013 settlement agreements. So again, they had 3 agreements. Let me bring it back on myself. They had 3 agreements. They had a 2012 agreement, a 2013 agreement. Then they had a most recent agreement a couple years ago in 2022. And Adidas is saying that they breached not only the 2012 agreement, not only the 2013 agreement, but also the 2022 agreement. So they're saying she didn't even try to comply with none of these agreements. She knew that she was going to breach them. And again, I know sometimes a lot of people, when they're starting a business, they're willing to be a little bit more riskier in trying to build the brand up and sell. And like I said, as of 2023, she sold over $130 million for her Aviator Nation apparel. So seems like that all that work maybe have paying out. So going back here, part B, Aviator Nation prior infringement and 2012 agreement and the 2013 settlement agreement. In or around 2011, Adidas became aware that Aviator Nation was offering for sale essentially these items. Now she was definitely in trouble for this. This was Adidas all day. And I think she maybe just tried to get some free marketing and advertising because she knew this was not going to fly. 3 stripes, You're not even doing the 4 stripes. This was going to get hit all day. The 3 stripes on the sleeves, across the front shirt, on the diet. You was going to get hit all day with that. Yeah, she was going to get hit all day with that. So this, again, 2011, this when Adidas found out she was selling these items. So paragraph 40, soon thereafter, Adidas communicated the objections to the page in Aviator Nation. And seems like they resolved the dispute. Paragraph 41, that was culminated in a settlement agreement, a 2012 agreement. As part of that agreement, Aviator Nation agreed not to produce, offer for sale, manufacture these apparel, which I think that's fair. Obviously, you're talking about 3 stripes. And as we talked about, Adidas has a trademark, a famous trademark on those 3 stripes. So I think that 2012 agreement, I think that was good for her to do to avoid suit. Notably, nothing in 2012 agreement permitted Aviator Nation to sell products featuring 4 parallel stripes. So again, they're saying in the agreement, Adidas is saying that nothing permitted her to sell stripes featuring the 4 parallel stripes. But what is this paragraph not saying? Again, let's read this. Words have meaning. So let me know in the chat, do you guys see what I'm looking at? So it's saying in the paragraph 42, nothing, let me blow it up. Nothing in the 2012 agreement permitted Aviator Nation to sell products featuring 4 parallel stripes, and no such products were included in that agreement safe harbor exhibit. In fact, in the 2012 agreement, Aviator Nation especially agreed not to produce or sell products confusingly similar. So what does that say? They're saying that nothing in the agreement allowed her to sell these 4 stripes, but as an attorney and I'm representing Paige, I'm gonna say nothing in the agreement prevented her from selling it either. Okay, it's one thing to say we're not allowing you to sell it, but nothing is saying that I can't sell the 4 stripe marks. I have a trademark on it that we just looked at, and nothing in this 2012 agreement is saying that I can't sell 4 stripe marks. And again, the Adidas attorney is saying, matter of fact, she said that she's not going to sell any products confusingly similar. Hey, I thought that I thought the 3 stripe stuff was confusingly similar, but I didn't think that the 4 stripe stuff, the shirts with the 4 stripes on it was confusingly similar. That's my argument. As attorneys, man, we got to try to see both sides of the aisle. So the Adidas attorney is saying, hey, this 2012 agreement, nothing allowed her to sell items with 4 stripes. And she said that she wouldn't sell items that's confusingly similar. I'm saying, well, number one, nothing said that I couldn't sell 4 stripes, and I didn't think the 4 stripes were confusingly similar. So that's my comeback to what the attorneys are saying in paragraph 42 or paragraph 42. So let's move on to paragraph 43 of the complaint. And again, for those of you who just joined, hey, please hit the subscribe button, hit the like button if you like the comment. We're breaking down this Adidas lawsuit. For those of you who just joined, and I see we got maybe some new visitors. We're breaking down this Adidas lawsuit of them suing Aviator Nation, a clothing and apparel company on the West Coast. They have 5 or 6 brick and mortar locations. They have an online presence. This is not a small company. They have done $130 million in revenue last year. So this is a fairly decent sized company. I'm not sure it was a big company or not, but I would say $130 million. That's a fairly big sized company. So let's go to paragraph 43. So again, we're talking about the 2012 agreement. Now it seems like we're moving on. 6 months later, in around October 2012, so this 6 months later after the 2012 agreement, Adidas became aware that she was again offering products with the 3 parallel stripes and violet. Man, Adidas, hey, I can't help you out with that, Paige. If you just agree that you're not going to sell the 3 stripe marks, and 6 months later you're still selling the 3 stripe marks, as an attorney, I'm not sure if I can defend that. Especially if you said in the agreement, if you agreed to not sell them, and you're selling them 6 months later. That's what the Adidas attorney is saying. That's what they're saying in paragraph 43. Let's read it. Adidas became aware that Aviator Nation was offering for sale and selling apparel featuring 3 parallel stripes in violations of Adidas trademark rights in breach of the parties' 2012 settlement agreement. I can't help you with that. So if you're selling these items after the 2012 agreement, what do y'all think? I don't think you can get away with that. That looks pretty close to Adidas to me. And you said you were going to stop selling the 3 stripes. Yeah, I can't defend you on that one page in Aviator Nation. But let's see what you say. So in paragraph 44, Adidas contacted Aviator Nation again about selling the 2012 infringing apparel. The parties came to another agreement. Hey man, Adidas was not trying to sue this lady. Again, like I said before, sometimes you gotta show them the hard way. 2012 agreement, she said she was not going to sell. 2013 agreement, a year later, they entered another agreement. That 2013 agreement, paragraph 45 here, this agreement affirmed Adidas' rights, and pretty much they affirmed the 2012 agreement. So then this is the latest agreement, 2022 agreement, in the present dispute. So after this breach of contract of the 2022 agreement, Adidas said, man, we're going to slap you with a lawsuit because you're not learning. So paragraph 46, in spite of the 2012 and 2013 agreements, May 18th, Adidas again learned that Aviator Nation was offering to sell the following products. So these are the products. Now, what do you guys notice in these products? The ones before that she was selling had the 3 stripes. I guess she said she learned her lesson. Okay. Y'all got me. I'm not going to sell the 3 stripes. You know what I'm going to do? I'm going to add 2 more stripes. I'm going to add 2 more stripes to it. So, again, she start selling this, the 5 stripes, sweatpants and sweatshirts. Trademark infringement or not? This is what she's selling as of 2018. That again came on Adidas' radar. She definitely not gonna get away with that. Not the 3 stripes. I guess she got the peace sign. She got the Aviator Nation logo. But yeah, Adidas not gonna go for these 3 stripes. So again, I think you may have more of a fighting chance with the 5 stripes, but no, with these 3 stripes, you're not gonna get away with it. So paragraph 49, while attempting to resolve the dispute. So again, Adidas is not trying to sue this lady. This is the 3rd agreement they keep trying to. Man, this is interesting because companies typically don't do this. They don't give you 3 agreements over the course of 10 years before they slap you with a lawsuit. So I'm interested in knowing the backstory of why they waited so long, because typically companies don't do that. So what is Taylor saying? He's saying, I don't think it's infringement with the 5 stripes. It looks good to me. So Taylor, let me ask you this question. If Adidas has a trademark, which we all agree that they have a trademark on 3 stripes, ACT said McDonald's versus McDowell. Look it. This is the $1 million question that I want to ask you guys. If Adidas has a trademark on the 3 stripes, how many stripes would it take for it to be considered trademark infringement? Clearly, we know that if you have 3 stripes, that's trademark infringement. But can you have 4 stripes and then not be trademark infringement? Can you have 5 stripes? Can you put 10 stripes down the arms of the sweatshirt or the pants leg and that be not considered trademark infringement? ACT going back to the and what did he say? He going back to the I forgot the movie with Eddie Murphy. Coming to America, McDonald's versus McDowell. And I think this, if you had a McDowell's restaurant in real life, I can guarantee you that McDonald's is coming for that ass. So, Taylor is saying 3 stripes. So anything above 3 stripes, you don't think that Adidas can sue, or at least they have a good claim. So if she sells 4, if you have a company that's selling 4 stripes, which she has, 5 stripes, you're saying that that's not trademark infringement. That's interesting. Man, that's interesting. So again, mind you, trademark infringement is not being the exact thing. I had just posted this video. Go check it out. Where Dots, the company that's owned by Tootsie Roll, it's a Lansing-based company, cannabis company. Hey, cannabis is big here in Michigan. For those of you who don't know, hey, Michigan, we getting in right now with the cannabis. It's legal. You got shops selling cannabis everywhere, but it was one cannabis shop that they was called Pot Dots. So Dots is the candy company, And Pot Dots was the cannabis candy company. But the Pot Dots, hey, they get you high as opposed to just some good snacking food. And Pot Dots, Tootsie Roll, who owns Dot, sues them for trademark infringement. So again, it doesn't have to be tailored to your point. It doesn't have to be literal infringement. If it's confusingly similar to the consumer, then it's not infringement. And according to you saying, hey, I think you should be good with 4 stripes or 2 stripes. So anything above or below 3 stripes. That's interesting. He follows that up with the disclaimer, though. I'm not an IP attorney. I just don't think I'd be confused with the brand. And hey, to that point, I do agree with you. I do agree with you that it's probably less likelihood of confusion with the 2 stripes or the 4 stripes or the 5 stripes. And again, I think you would be a good representation of Paige, because I think, hey, Paige knew when she was signing these early agreements, and those early agreements, she probably knew that she was breaching a trademark, because she's literally selling stuff with 3 stripes. And as you just pointed out, if you got 3 stripes, you pretty much going to be on the hook. But then what she did was she went to 4 stripes, and Adidas came to her and said, hey, stop selling that. And she's like, okay, I'm going to sign the agreement. But I think she was just building up the company. And now, hey, in 2024, you're going to slap me with this lawsuit? Man, I just made $130 million in annual revenue last year. And as Taylor said, what is he saying? He's saying, I don't think I'd be confused. What he say? 4 stripes, you good. 2 stripes, you good. I think that's part of the thing now. I think Paige, she knew that, hey, I'm not going to be able to compete, or I'm not going to waste the money. I'm growing a business, so I can't be kind of bottled up in this lawsuit with Adidas, because I don't have the money to compete with them. And even though I think I'm right, and I think this is not trademark infringement, it became a business decision. So I'm gonna sign these agreements. But now I think she's saying, hey, look it, I done made $130 million. I'm doing a little better. She has no debt on the company. So just think about that. You build a company that had just $130 million in annual revenue. You have no debt, and you think that this mark is not trademark infringement. Hey man, Adidas, y'all can kick rocks at this point. We can go to court at this point. That's pretty much, in my opinion, I think that's what she came to the conclusion. We can go to court. I got the money, and as Taylor said, he doesn't think it's trademark infringement. So let's kind of get back to the lawsuit here. Again, there's 3 stripes. I think we all can agree that that's trademark infringement. I think Taylor is saying the 5 stripes and the 4 stripes, that's not trademark infringement. And I think she has a better argument with that. So going to paragraph 50 here. Adidas continued to attempt, but was unable to amicably resolve this dispute based on Aviator Nation. And again, I'm surprised that they let this go on for over 10 years before they finally filed this lawsuit. But that's neither here nor there. Aviator Nation, what they're saying, disputed based on. So Adidas is saying this is egregiously infringing apparel. So it's filed this style, Adidas America, asserting for breach of contract, trademark infringement. So they're essentially filing, among other things, trademark infringement, breach of contract, as well as these other things. Let's see. The parties resolved in 2019 lawsuit through 2022 agreement, which Paige signed. Okay, paragraph 53 here. Aviator Nation said they wouldn't distribute those apparel items that we looked at earlier. They said that again. So again, these are the apparel that they said they wouldn't sign, or they wouldn't sell, and that they're selling. As we looked on the website, these are some of her best sellers. So I would imagine that's the reason why she kept selling it. People wanted it. And heck, if you buying a $189 hoodie or sweatshirt with 5 stripes, or $156 sweatpants with 5 stripes, hey man, this one of your best sellers. I'll probably end up still doing it as well. What is Brandon saying? Hey, Brandon seems to be on the same page as Taylor. Hey, Paige. It seems like you got some supporters here. You got, again, there's likelihood of confusion. What will the consuming public thinks? At least seems like you got at least 2 people in the chat. Brandon right here saying he wouldn't be confused. Taylor saying the same thing. I'm not an IP attorney though. I just don't think I'd be confused. I think this is what Paige is banking on when she goes to court. I would imagine that is not going to be another agreement between these parties. So paragraph 57, does Aviator Nation agree to stop selling the items shown in 1? Seems like they kept doing it. Okay, whatever. Continue. Okay, that's what they're saying. They kept doing it. These are some more items again with the 5 stripes that Page and Aviator Nation is selling. Let's go to paragraph 59. Aviator Nations currently infringing apparel even emphasizes 3 stripes. Such apparel features 5 stripes down the outseam. Again, Brandon and Taylor is saying the 5 stripes is not infringing of the 3 stripes, it's not confusing of the 3 stripes. With 3 stripes that are much more prominent than the other 2 stripes. Whatever, although the 22 agreement includes narrow safe harbors, we don't really care about that. On infringing and on information of belief, Aviator Nation, they saying they willfully. So anytime you see that willful language, they trying to get treble damages, intentionally and maliciously continue using and confusing similar imitations of the 3 stripes. I don't think this is a good argument. They're saying, hey, based on how these pants or these shorts was displayed, they displayed them with only 3. Come on, man. I think that's I don't like that argument. Just because you displayed them with 3 stripes, again, maybe you have to fold them in a way that, unfortunately, the 3 stripes are the only thing that's being shown. So paragraph 63, we're going to wrap this one up here soon. All actions taken by Aviator Nation mentioned in this complaint have been. So yeah, hey, Paige, she's the head honcho in Aviator Nation. So they're pretty much saying that everything that you see has been approved by the CEO Paige. So we'll go through this first claim of relief. This is a short one. Aviator Nation nation's use of the confusingly similar imitations of Adidas 3-stripe mark at the direction of the CEO and founder Paige is likely to cause confusion, among other things, against the Adidas mark. Adidas and Aviator Nation, and they use the same channels. I think that's pretty straightforward. They both sell clothing. It doesn't look like they sell Aviator Nation sells shoes, but they definitely sell clothing. So that's what they're saying there. And at the direction of the page, Aviator Nation has used marks confusingly similar to Adidas mark. In light of the federally registered trademark in violation of 15 United States Code, essentially the Lanham Act, trademark infringement. So what you guys think? I'm not going to read the unfair competition, but as you go down here, another thing that she set herself up for is these agreements. Where is it at? I think she's going to be on the hook for breach of agreement, breach of contract. She's definitely going to be on the hook for breach of contract. So what do you guys think? This was an interesting one. And I think ultimately it was 3 different agreements, which I don't know for the life of me why they waited 10 years, over 10 years, and 3 agreements later to finally sue her for trademark infringement. Do you think it was a result that they think they didn't have a strong position? We saw Taylor, we saw Brandon says, hey man, 5 stripes, 4 stripes, that's not trademark infringement. I wouldn't know. Adidas has trademarks on 3 stripes. It's famous, yeah, but if I go into the stores and I see somebody selling apparel with 5 stripes on it, I don't think that's Adidas. Adidas has 3 stripes. So again, confusingly similar. We talked about earlier that it doesn't have to be a verbatim. If it's confusingly similar, then the person can still be on the hook for trademark infringement. And it looks like again, we at least have 2 people that think that, hey man, I wouldn't be confused. You selling these stripes or these clothes with 5 stripes or 4 stripes, I'm not confused by that. I know Adidas is 3 stripes, but putting that to a side, and I think that it is some arguments on both sides. And I think, again, Page and Aviator Nation, they're in a better position, just having made $130 million in annual revenue in 2023 and with no debt. And I think they can better handle this lawsuit at this point, because I would be extremely surprised and shocked if they enter to another agreement when you just entered into 3 agreements over the course of 10 years that just kept getting infringed. Maybe she's on the hook for breach of contract, but that's not trademark infringement. I'm not sure what that means in the end in terms of breach of contract. I would imagine that they have some type of in the breach of contract agreement, if any party was to breach, I think I would imagine that is some type of, okay, what do we get as a result of the breach? What are our damages? I would imagine that that's spelled out. But again, breach of contract, maybe that's better than trademark infringement. I'm not sure what the contract says as far as how much he would have to pay for breach of contract, but maybe that's better than trademark infringement in this case. But it's one thing that I did want to say. When you're using your specimen, don't try to be cute. And again, I saw the play with the attorney what he tried to do. Because again, we talked about it. We said it earlier. Aviator Nation has a trademark, and we'll bring it up one more time just in case you're just joining us. Aviator Nation has a trademark on the 4 stripes. You may ask, hey, how is she getting sued for trademark infringement for using a mark that she has registered? And as I talked about earlier, just because you have a registered trademark doesn't mean that you can't be sued for that trademark. But I think that you can say that she got this trademark kind of in bad faith. Because when she got the trademark, she didn't, again, when I talked about when you submit for a trademark application or submit a trademark application to try to register your trademark, you have to submit what is called a specimen. And that specimen is showing an example of how you're using your trademark logo or term on your goods and products. So now again, obviously, if you're in clothing, you're selling shirts, you're selling hats, t-shirts, sweatpants, jogging pants. You don't have to provide a specimen for each item, but you do have to provide at least one specimen showing how that mark is going to be displayed on one of your products, in this case, one of your clothing items. And the way they displayed that item was on a tag. And again, I just want to be clear, because I think she's going to be okay at the end of the day, but this can come back and hunt you trying to do this. So what she tried to do is, this was her specimen. So you can see there to the left, you have the AN. So that's cool. I don't think Adidas has an issue with that. But you can see these 4 marks. She's showing it on the tag. And I think as the examiner was reviewing the application, the application even said the description of the specimen is showing these 4 stripes used on a tag. So I think they're like, okay, yeah, this is on a tag. Even though it's clothing, this is on a tag. This is not a trademark infringement or confusingly similar with Adidas 3 stripes marks that are being used on the arms of apparel or on the pants leg of sweatpants and stuff like that. But Paige started using it on the apparel in a similar way that Adidas has. Now, again, Taylor and Brandon doesn't think that it's confusingly similar, but it's definitely similar. And I think that if she would have said from the beginning that she was using her trademarks in this way, so in other words, if she would have submitted this as a specimen, for example, Adidas would have said something to her. If she would have submitted this shirt as a specimen, or she would have submitted these pants as a specimen, I think Adidas would have said something, as well as the USPTO, the trademark office, would have said something. But I think she showed the tag is a specimen to get the mark registered. And then she's like, hey, I got a registered mark. I'm going to start putting them how I see fit on the clothing. And she started putting them across, similar to Adidas, on the arm, similar to Adidas, and around the pen leg, similar to Adidas. Now, again, notice I'm saying similar to Adidas. Is it confusingly similar? That's where trademark law comes into play at. We have a few people who don't think it's confusingly similar, but I would think we all think is at least similar into the way that Adidas uses their 3 stripes. But again, hers is 4 stripes as well as 5 stripes. So again, I think she's going to be okay in this situation, but be mindful of that, because that can backfire later on you to do that, to get the trademark and then use it in a way that you didn't say that you're going to use it, and all of a sudden, that can backfire on you. Again, you can get your mark petition to be canceled, amongst a lot of other things. So let that be a learning lesson. Again, I'm gonna continue to try to follow up on this. I would love to get Paige on this to just see how she built her company, man. To go from starting in 2006, and 18 years later, she started this thing at 24. I think she's 44, 26 or whatever. She's 44 now. She started this thing 18 years ago, and she's just recently done $130 million. They have no debt. So she's the real deal. She's a beast. And so kudos to her for that. But this was an interesting case study. Hopefully you guys enjoyed this one. We're gonna come back next week with another one. I may have to pre-record that one just because I have some travel arrangements next weekend. So I may have to pre-record that and put that out without doing a live stream. I always appreciate everybody who participated in the chat. Seems like we had some participation with Brandon. Matter of fact, this is what I'm gonna do. For anybody who wants to come online and kind of give me their thoughts, I would love to hear from Taylor if he's willing to come up. Also, Brandon, if he's willing to come up. Hey, if Charles is willing to come up as well, or anybody, I just posted the link to the stream in the chat. So if you guys, I'll wait for a couple seconds here, a couple seconds. If you guys want to come up, just click the link. You see the link there. Click the link to be able to come up and let me know your guys' thoughts. I would like to know, again, at least Taylor and Brandon said it isn't confusingly similar. I want to know a little bit more into that. If not, no worries. I'll give you guys a couple more seconds in case you guys do want to come up. But again, I appreciate everybody. CT, let's get it. Hey, CT even said that McDonald's versus McDowell's, which this was, obviously, it was in a movie. It was like, it was one of the trademark defenses. That's why the studios didn't get hit for that. But you better believe if you had a McDowell in real life, McDonald's would be hit with a lawsuit. And I almost guarantee you that they won't wait 10 years to sue somebody. They won't. That's crazy that just agreement after agreement before you finally get hit with the lawsuit. Okay, so it looks like those guys don't want to come up. So we're going to end it now. Again, I definitely appreciate the participation. Hopefully you guys got something out of this one. Again, I'm trying to bring you guys valuable content, not only from that's entertaining, but I want you guys to be able to add value to you guys' lives. I know a lot of people these days are starting a business based on everything that's going on in the world, having to have a second hustle or a second job and not relying as much on the main job. And again, protect your IP. However you go about it, protect your IP, whether it's trademarks, patents, copyrights. If you have a trade secret, and make sure you're protecting your IP. This stuff is extremely valuable. Matter of fact, on the How I Built This podcast, when I listened to it yesterday, Paige was talking about the CEO and the founder of Aviator Nation. She literally talked about how she has had multiple people come up and offer her $500 million, $400 million, $500 million for her company. Again, it just did $130 million in revenue last year. It has no debt. And she said on How I Built This podcast, man, this lady's a beast. I know we're kind of making fun and joking and kind of talking about the lawsuit and stuff, but this lady was a beast. And she started this company in her mid-20s, and she has got it to the point that at 44 years old, she's making millions of dollars. And if she wanted to exit, she talked about multiple people wanting to buy her company for $400 million, $500 million. So again, that just goes to show, protect the IP, protect the brand, build the brand. And the lawsuits, unfortunately, that stuff is going to come with it. Hopefully you don't do anything to invite the lawsuits. I think in this way, I think it was really a delicate balance between I'm pushing the edge. Okay, I'm going to enter to these agreements. Maybe I'm doing some stuff that I know is trademark infringement, but companies don't want to sue you. So they're going to send you a cease and desist letter, maybe have you sign an agreement. But if you continue to breach the agreement and continue to do the things that you said you're not going to do, use their mark. If she would have continued to use that the three-stripe mark, she would have been hit with a lawsuit, and she would have been, as at least Brandon and Taylor said, that would have been trademark infringement because it's the three stripes, and it's essentially smack dead with, it would have been more or less confusingly similar with Adidas trademark. But she continued to, sign the agreements, continue to put out her clothing. She went to the 4 stripe. She went to the 5 stripe. Hers has the colors. So she has some differentiating factors. And I think now at this point, she's not scared to get into a lawsuit with Adidas. She has the money. And I think she has a good fighting chance for this to not be trademark infringement. So I'll continue to try to keep my eye on this one. In the meantime, in between time, hopefully you guys got something out of this. I'll see you guys next week. Take care. Peace.